Imagine this for a moment. You clock in every day for 20 years. You clear every single departmental test. But you watch all of your colleagues move up the ladder while you stay put.
And the reason you're given.
The government, your employer, just looks at you, an employee with a permanent disability, and says, sorry, we haven't actually written the rules for your promotion yet.
It's an unbelievable situation. And that core injustice is really the human story behind the landmark Supreme Court ruling we're doing a deep dive on today. State of Kerala v. Leesamma Joseph.
Our mission here is to unpack how the highest court in the land said a very loud and clear no to that kind of bureaucratic stagnation.
Right, to really force the state to act on rights that are already on the books.
So let's start with the person at the center of it all, Mrs. Leesamma Joseph. She joined the Kerala Police Department way back in 1996.
She came in as a clerk typist, and it's worth noting she was appointed on compassionate grounds after her brother passed away.
And the crucial fact is that she lives with a 55% permanent disability from post-polio residual paralysis.
Exactly. And she performed her duties well, but she saw her career just completely stall. She argued, that the 3% reservation from the Persons with Disabilities Act of 1995 should have meant promotions for her much, much earlier.
We're talking senior clerk in 2002, cashier by 2012, promotions that just never happened.
So she went to court. The Kerala Administrative Tribunal first dismissed her claim.
But the Kerala High Court saw it differently. They reversed that decision, relying on precedents that said, yes, reservation does apply to promotions.
And, well, as you'd expect, the state of Kerala then appealed to the Supreme Court.
Okay, so let's get into the state's defense. What was their main strategy here? It seems they had two key arguments.
They did, and they're classic bureaucratic tactics. First was what we can call the identification loophole.
Okay.
They argued that they couldn't grant the reservation under Section 33 of the Act because they hadn't finished identifying which posts were suitable for persons with disabilities under Section 32.
Wait, hold on. So their argument was, we failed to do our mandatory homework from Section 32, therefore we don't have to follow the law in Section 33.
That's it, exactly, using their own administrative failure as a shield.
Wow. And the second argument?
That was the entry method barrier. They claimed that because Mrs. Joseph was appointed on compassionate grounds, not through the PwD quota, she wasn't eligible for reservation benefits in promotion down the line.
But this is where the Supreme Court really stepped in and, well, provided a masterclass in how to interpret social welfare law.
It really was. On that first point, the identification of posts, the court was blunt. It ruled that the duty under Section 32 is absolutely mandatory.
Meaning the government can't just cite its own delay as a valid excuse?
Not at all. And then on the scope of reservation, the court reaffirmed that appointment as a term includes promotion. It has to.
So a reservation applies to the total cadre string?
Yes, both direct recruitment and promotions. They said anything less leads to the stagnation of the disabled, which is just unacceptable.
And that completely knocks down the state's second argument, the entry method one.
It does. The court held that the source of your recruitment, how you got the job in the first place, makes no difference. The test is simple.
Do you, the employee, have a benchmark disability at the time you are up for promotion?
That's the only question. If the answer is yes, you are entitled to the benefit, period. The verdict was a clear dismissal of the state's appeal. Leesamma Joseph was granted retrospective promotion with all notional benefits.
And the court didn't stop there. It issued a mandamus, which is a direct judicial command with a deadline.
A 3-month deadline for the state to identify all the posts and implement this reservation. That hard deadline signals zero tolerance for any more bureaucratic foot-dragging.
Which brings us to the key takeaway, Fanu. Whether you're an employee or just following along, administrative delay is not a valid legal excuse.
That's the nugget. If the law gives you a right, bureaucratic inaction can't take it away. And that inaction is now clearly actionable in court.
And for any legal professionals listening, this judgment is huge strategically. First, it confirms reservation applies to the total cadre strength. That's a big deal for calculating quotas.
And second, it cements Section 32, the identification of posts, as a mandatory duty for the state, not some loophole they can use to deny rights under Section 33.
It really feels like a shift in mindset, doesn't it? Forcing government to move from finding reasons to deny benefits to finding ways to grant them.
Absolutely. It's about proactive implementation, not passive resistance.
Exactly. So here's the final thought for you to chew on. If the state has a legal duty to implement these rights now, without waiting for internal rules, think about how many other areas of social welfare law, pensions, grants, access schemes are currently being stalled for the exact same invalid reason. That's the real potential impact this judgment unlocks.